I take it we're going to start with you, Advocate. Yeah, thank you.
Thank you.
I
Thank
think
you,
you
Madam
can
Chair.
proceed. Thank you.
Members of the panel. Mr. Boyson, you're now in private, so I can call him Mr. Boyson, or is it still Lieutenant General?
Madam Chair, I retired with my rank and I'm still known as General Boyson, so I prefer you to address me as General. Thank you.
Okay, General Boyson.
Will do.
Can I just try to, as fairly as possible, summarize the gist of your evidence? The gist of your evidence is that you are not guilty of racketeering. There is nothing in the docket that links you to the some 28 or so killings that were investigated and for which you were subsequently charged under the heading of racketeering. There's no evidence. Notwithstanding this, your complaint is that Ms. Giba had authorized these racketeering charges, and in that regard, she erred, and according to Judge Govan, she acted irrationally. Would that be a fair summary of the evidence?
That's right, Madam Chair.
So, General Boyson, can we agree this? I'm not here, we're not here, and the panel is not here to debate your guilt or innocence. That is for a court of law to decide. Do you agree with that proposition?
I agree, Madam Chair.
We are here to debate, discuss, and find some way forward in relation to the conduct of we act for Ms. Giba and my colleagues act for Mr. Mokgoro. Do we agree with that?
I do, Madam Chair.
So, in relation to your matter, the General Boyson racketeering charges, the only relevant issue relates to the criticisms leveled at Ms. Giba in that regard. You agree with that?
Can you, Madam Chair, can the question be perhaps rephrased? I'm not too certain as to what is meant by the question.
Kindly.
Sorry, Madam Chair. It's more what I've put to you. I've put to you that we are concerned here in this inquiry with Ms. Giba and her conduct, and whether she is a fit and proper person to be in the position that she held as acting National Director of Public Prosecutions when she authorized the racketeering charges against you.
Madam Chair, that's my understanding, although I'm not part of this panel, so that's my understanding.
I think that's the kind of matter that, or where my colleague, Mr. Katz, will be able to give you some legal advice. Those are the parameters really of what I'm going to try and focus on today. Your evidence in many respects, with respect, strayed from that and into other areas, and I'm not going to ask you questions about those areas, because frankly that doesn't concern Ms. Giba.
Sir Aaron, sir, can you kindly pull the mic nearer?
Nearer.
Yes, yeah, thank you.
So let's begin at the beginning, and that on this side. Where should I put it? Should I put it there? Is that better?
Yeah, you have to speak into the mic.
Thank you. I don't have to repeat the other stuff I've mentioned. You heard that. Thank you. Let's start at the beginning, and one of the judgments that concerns you and that gave rise to this inquiry, which is the Govan judgment. Now that judgment, we will find, Madam Chair, at folder B1. Now, with reference to paragraphs 38, 39, and 40, I will draw the following conclusions on which you are at liberty to comment. The first one is that Judge Govan did not or does not, in his judgment, absolve you of any guilt. The second one is that, and you'll see this from paragraph 40 of the judgment, that you had, amongst other things, also asked in the relief that you sought for an interdict, and that against further prosecution, and that was refused. The third one is that the judge, the learned judge, makes it very clear that he dealt with the matter only on the pleadings before him. And I'm sorry if it might be a bit technical, but you are a more than experienced policeman, and I think you know what I mean. The fourth observation is that the memo that was placed or that was presented to you on the screen by the evidence leader, that memo was not before Judge Govan. The prosecution memo, the NOCO Miami memorandum. That memorandum, Madam Chair, is at G525. 535, sorry. And lastly, the decision of Govan J was appealed, but that appeal was withdrawn. It may or may not be within your knowledge. It was withdrawn by Mr. Tasana once he assumed the position of NDPP. He withdrew the appeal on the leave to appeal on the 25th of March 2014. So, have you got any comment on any of those? I think I counted 5 statements, observations that I drew from the judgment.
No, I don't,
I would
Madam Chair.
imagine, Mr. Arendse, you've mentioned, yes, 5. Wouldn't it be fair if you took them one by one and sought his response per issue? Thank you. Instead of making it globular, because then we have written them down, he hasn't written them down. It would make much more sense if you took him through what you've been placing on record.
I think that's a fair request. The first one, General Boyson, was that the Govan judgment doesn't absolve you of any guilt.
He does not, Madam Chair.
The second one was that you sought an interdict against any further prosecution, and Judge Govan refused that interdict.
That's indeed so, Madam Chair.
The third one was that Judge Govan dealt with the matter before him on the paper, on the pleadings that were before him. He didn't take any other extraneous matters into account.
Well, I couldn't really comment on that, Madam Chair.
The fourth one was that Govan J didn't have the prosecution memo, the Mahema Noko memorandum that my colleague took you to in chief. That's at G535. That memo was not in front of Govan J.
I will accept that, Madam Chair.
And then lastly, the decision at the time when Ms. Giba had the authority to do so, presumably, was, or the intention was noted to apply for leave to appeal, but that leave to appeal application was subsequently withdrawn by Mrs. Kasana when he assumed the position of NDPP.
Madam Chair, I'm not too sure what happened there. I'm not sure whether it was in fact filed and not prosecuted, or whether before it was filed it was decided not to prosecute the matter. But what I do know, it was not appealed.
Now, if I may just then, for the record, honorable panel members, read from the judgment of Judge Govan in support of those propositions that I've raised with General Boyson. At paragraph 38 of the judgment, he says the following: I hasten to emphasize that this outcome is based purely on the facts of the present case. It does not provide a basis for opening the floodgates to applications to review and set aside decisions to issue authorizations to prosecute under Section 2.4 of POCA. If the respondents had properly understood the principle of legality, it seems to me that their responses to demands for documents or reasons might have been different. Had she outlined in basic terms what these documents and information comprised, said that she had relied on them, and shown that they had included information linking Mr. Boyson to the offences in question, this application might not have seen the light of day. The rhyme or reason test for rationality might have been satisfied. The level of disclosure of the NDPP for offences of this nature cannot be such as to prejudice the state in its conduct of a future trial. In my view, it will therefore not require an exacting, still less an exhaustive level of disclosure. De Vries, that's a reference to the case of De Vries. It's a Cape case, 2009 Cape case, found that the consideration of a request for authorization forwarded to the NDP under cover of a letter summarizing the form and content of the charge sheet, setting out a detailed background to the charges and summarizing the evidence was sufficient. It is certainly not necessary to disclose every detail of the state's case, strategy or evidence where this is not subject to the criminal discovery process. In the light of the provisions of POCA, it is also not necessary to have before her sworn statements from witnesses on which the state intends to rely. I expressly refrain from making a positive finding as to the level of disclosure necessary in meeting an application such as the present one or the detail required. This can only be assessed on a case-to-case basis. Now, if I may just pause there, General Boyson, do you agree, or do you accept, or if you prefer not to engage with me because perhaps it's just legal jargon, that the threshold that the decision maker, in this case Ms. Giba or any other NDP, PP, to authorize a 2-4 prosecution, the threshold is quite low. And what is required from time to time is perhaps just a memo from the prosecutor or the lead prosecutor submitted to the NDPP, setting out in summary form what the case is about, and then seeking to justify why an authorization should be granted.
Madam Chair, I would not like to engage with regards to the findings of Judge Govan towards the latter part of his findings. What I'm prepared to testify about relates to what I complained about in papers and what happened consequently with regards to my complaints in papers to court.
Okay. Can we accept, or would you accept this? That certainly what a Section 2-4 authorization does not require the NDPP to do is to read the whole docket and to read each and every statement, to look at the ballistic report and the evidence and all those kinds of issues that typically the state would be required to prove in a criminal trial.
Madam Chair, that is trite in law.
So it's the exercise is quite a cursory kind of exercise. You read, you presumably ask questions and so on, but a 1-2 page memo, the cases seems to indicate there's that De Vries case, there's another case of Chow, which is also a Cape case in 2009, where I think it's Judge Bozilek also said that a memo is enough. You can't hamstring, you can't hamper the exercise of the executive and sort of weigh them down in a lot of paper. They've got work to do. NDPP, there's a lot of matters. They've got a lot on their plate.
Madam
Chair, I'm sorry to interrupt. Can I just suggest that these are these are legal questions that you're putting to Mr. General Boyson, and I just wonder if it's appropriate that he would be able to answer that sort of thing.
Not only that, I would have made a different point, because it would be interesting for me when you say it's been held in the Cape, just give me the proper citation and the paragraphs, preferably read from them. But I think it's a matter for argument, as has been pointed out. As long as you don't forget to argue the point when the time comes.
No, I'll never forget that point. I argued it previously to another case we're going to get to soon. The case of De Vries is 2008-4, 441, bracket C, paragraph 33. It's in the South African law reports. And the case of Chow, CHAO, 2009, brackets 2 SA, 595, bracket C, paragraphs 32 to 34. Honorable members of the panel, the point, and to my colleague, General Boyson is a very experienced, you took him through it, and we don't contest his vast experience in these matters. But where I'm at now in my cross-examination of Mr. Boyson is that his evidence took the panel through a lot of documents, statements, reports, a lot of finer detail that would relate typically to the kind of crime with which he was charged. And he accepted my proposition at the outset that in summary his evidence was to show that it's not him. It couldn't have been him. He's not guilty. So what I'm trying to demonstrate to the panel, and yes, it is a matter for argument at the end, but it's important for the further conduct of this cross-examination that we clear on the parameters, that I'm not here to debate those issues with Mr. Boyson. And to the extent that he may have mentioned something or drawn the panel's attention to a statement that may say something negative about Ms. Giba, and I don't contest it, then it's sort of, oh, you didn't contest it, now it stands as evidence against you. I'm not here to do that. I'm also trying to be helpful and saying, look, this is her role as an NDPP. And I think thus far, I think Mr. Boyson accepts that would be the nature of her role. I think it's just this last part now, this memorandum, what would be required to be put in the memorandum and so on, and I've now refer you to the authorities.
But you're also not going to cross-examine him as if he is a legal expert.
No, I think, in fact, it arises from his examination in chief. He explained in quite helpful terms to us. And some of us have that experience, but I thought it was quite helpful to those who may not have had that experience of how it works. How do you start opening a case and where it goes and so on, and the detectives deal with it. That was his evidence.
Based on his experience.
Yes, based
as a
on his
detective.
experience.
Yeah.
And so I don't think, but I don't need to take it any further with respect. So I think the last point that Advocate Moroka, you requested me to do was to ask General Boyson to comment point by point on the 5 propositions. And I don't know, Mr. Katz, whether we went through it now. I think we did. So I now went through the 3 paragraphs in Govan J's judgment, again, to reinforce these 5 points that I made and which I gave General Boyson an opportunity to respond to. At paragraph 39 of the judgment, the learned judge said, "It is important to note that the above findings do not amount to a finding that Mr. Boyson is not guilty of the offences set out in counts 1 and 2 and 8 to 12. 1 and 2 are the racketeering charges, and 8 to 12 are the predicate offences. That can only be decided by way of a criminal trial. Setting aside the authorizations and decisions to prosecute also do not mean the fresh authorizations cannot be issued, that fresh authorization cannot be issued, or fresh decisions taken to prosecute if there is still a rational basis for these decisions." Now, we also know now, General Boyson, that subsequent to this Govan matter, former NDPP Advocate Abrams, he had issued another authorization in respect of the same charges. Is that correct?
That's correct, Madam Chair.
And that is also the subject of a review by you and others in the High Court.
That is correct, Madam Chair.
And then to emphasize the other point that no interdict was granted to General Boyson, paragraph 40 deals with that, where the court said that pre-E in paragraph 3 of this judgment seeks to interdict the NDPP from issuing fresh authorizations in the absence of the NDP having before her facts under oath implicating Mr. Boyson. A final interdict is thus sought. Then deals with the requisites for a final interdict, a clear right, and so on. And then the court says Mr. Boyson has a clear right to a lawful decision-making process. He certainly has no right at all to such a decision being taken only if affidavits connecting him to the offences are in the possession of the NDPP. I have mentioned above, for example, that hearsay and similar fact evidence is admissible under certain circumstances in respect of offences under Section 2, brackets 1 of POCA. I am not going to read the rest of that paragraph. Now, can I also just take you to J80 of the Dropbox? It's a memorandum from Advocate Lawrence Otis, which is dated the 3rd of February. J80. J80 in the Dropbox, yeah. Dated 3 February 2015. J80. If I may take you to, now, I'm not sure, General Boyson, you probably know that Advocate Otis acted for the NDPP in that matter before Judge Govan.
I am, Madam Chair.
Yeah. Now, this matter relates to an alleged concession that was made by Advocate Otis, and it's referred to by Advocate Otis in this memorandum when he says, when the matter was argued before, and it's again just for your comment, General Boyson, when the matter was argued before Honorable Mr. Justice Govan, I only made one concession, and that was in relation to that court possibly having jurisdiction. I did not have the other concessions that were attributed to me in his judgment. A record of the proceedings may be obtained to substantiate my contentions in this regard. And, my lady, I've made a reference to the transcript at page 67, line 25 to page 68, line 20, where the concession that's referred to here is that there was no evidence that implicates General Boyson. Then at paragraph 8, I'm going back to the Advocate Otis memorandum. Nevertheless, as alluded to above, the Honourable Mr. Justice Govan attributed various other concessions to me as appears from his reported judgments. My junior and I consequently compiled an application for leave to appeal. A copy of the document is available and discussed in a consultation with various members of the NPA. It was then filed on behalf of the acting NDPP. However, on 25 March 2014, the newly appointed NDPP, Mr. Kolisi Kasana, decided not to appeal against the judgment in the Boyson's matter. So, I mentioned this, General Boyson, to demonstrate the fact that counsel obviously didn't differed with a finding in the Govan judgment relating to whether you were implicated or not in any of these statements. But I do it purely for that purpose. I don't need to argue with you whether it's so or not. Now, I've mentioned to you that a fresh decision was then taken by Advocate Abrams on the 13th of February 2016, and that matter is now on review. In fact, I think, just for the record, Madam Chair and honourable members of the panel, we've got 3 reviews. We've got the original one from General Boyson. Then we had, that was before Mr. Justice Govan. Then we had the Naidu one, also relating to the same decision that was overturned by Judge Govan. And then we have a consolidated one of Govan and Naidu, which is now also before the High Court, I think in Pietermaritzburg. And that application, Madam Chair, is subject to certain directions that were issued by Lopez J in that division, and I think Mr. Boyson's replying affidavit was due last Thursday. But I suppose that's a fight for another day. But the point is simply that these matters are now all pending, General Boyson.
That is so, Madam Chair.
So I want to put it to you, Mr. Boyson, and that's why I've tried to put it in a hopefully forensically comprehensible manner, that it is hopelessly premature for you to testify before us, before the panel, that you shouldn't have been charged, and that even if you were to be charged, you would prove, well, obviously the state has to prove your guilt, but the charges would be ill-founded because there shouldn't be any charges against you. That is the point I'm making from what I have described to you, because that is where we are at the moment. These matters are hanging in a court of law, and there are various possibilities. Do you accept that?
Madam Chair, that's not for me to decide. I think that's indeed for the panel to decide. I'm not debating the merits or the demerits of the criminal charges pending. What I'm testifying about is the process that was followed to prosecute me.
So the question we ask ourselves, Mr. Boyson or General Boyson, is, what was the point of your evidence? You mentioned you were suspended, not by Ms. Giba, but by SABC. There was a disciplinary hearing chaired by a colleague of ours, Advocate Kazim. That disciplinary was instituted by Ms. Vieja when she was the National Commissioner, not Ms. Giba. What was the point of all that other than to provide some good theatre here for the media and for others?
Madam Chair, I'm not here for the media. I'm not here for theatre. I've been exposed to the media for the last 7 years, so I'm not here for theatre or for the media. I'm here at the behest of the evidence leaders who has requested me to assist this panel, and I'm here purely to assist this panel to come to a conclusion. That's the only reason why I am here today.
Okay, just keep it this. Well, I accept, and perhaps, not perhaps, but I'm sure that this was an important platform for you today to go some way towards clearing your name and to deal with 6-7 years of what you regard as negative publicity about you and all kinds of allegations being made against you.
Mr. Arendse, is that a fair question, considering his response that he's here at the behest of the evidence leaders? You think that's a fair question to ask him?
Madam Chair, it wasn't even a question. I put it to Mr. Boyson.
Yeah, do you think
That
it is
this-
fair to
that-
put that to him?
Well, I think, well, maybe I should ask him. I think if he was requested to testify here,
Yeah, I think that's what you should ask.
which I'm surprised that there was such a request, because I can assure the panel, and my team is here, we were quite prepared to accept Mr. Boyson's affidavit. Why? Because we've been engaged and engulfed in several court applications where Mr. Boyson's version is before the courts, our client's version is before the courts, and we didn't think it was necessary for him to come and testify before the panel in terms of the rules of engagement that we had agreed.
All I'm saying to you is, it is not fair to put that to him because of the reasons that he has indicated. He didn't just offer to come and give evidence, he was asked to give evidence.
We accept that. Now, just again, just for the record, General Boyson, you know that the Govan judgment was then debated in the striking off application of the GCB before Justices Lahodi and Hughes, subsequent to that Govan judgment.
I'm aware of that, Madam Chair.
That judgment, Madam Chair, is at B18. That's the judgment of the GCB versus Giba and Kwebi and Zinyati, delivered on the 15th of September 2016. Now, if it's not fair, then you can just tell me and I won't hold it against you. But perhaps Mr. Katz will help you. This time round, General Boyson, there's now a full picture or a fuller picture before the two justices, Lahodi and Hughes. There's Govan's criticism now arising of the criticism of Ms. Giba's alleged mendacity. That then comes before the two justices, and Ms. Giba now has an opportunity to explain herself, defend herself, call what you will. So, if I may just take you, so I'm not sure if you want to comment on that there's now a fuller picture before the two judges than was before Judge Govan.
Madam Chair, I'm going to attempt to respond to that. In my view, not everything was at disposal. I think it was Judge Lahodi and Hughes. Are you referring to that judgment? So what served in front of Govan did not serve in front of those two judges, as far as I'm aware.
Okay. So a different set of facts served before the two judges than before Judge Govan?
Madam Chair, that's not what I'm saying. I'm saying what served in front of Judge Govan, all the papers, in other words, in the Govan matter, as far as I know, did not serve in front of Judge Lahodi, and I think it was Hughes. And if I may add, my understanding is in the Govan matter, the question that was raised related to the principle of legality and rationality, whereas in the GCB matter, I think it was, it related to ulterior purpose. That's my understanding. which, by the way, in my view, are two different concepts that should not be conflated.
Do you agree that the issue before Justices Legodi and Hughes was a far more serious issue, certainly for Ms. Giba?
I would not venture to answer that question, Madam Chair. In my respect, my liberty was at stake, so I'd stop at that.
Yeah, that's why I deliberately framed it in that way. I said, as far as Ms. Giba is concerned, the Govan case was important for you on a personal level, because the court there found that she acted irrationally by instituting the racketeering charges. So you felt vindicated.
Indeed.
But arising out of the criticism in that case, Ms. Giba's own fitness and properness to be an advocate is now at stake before those two judges. So I'm saying that certainly as far as she is concerned, that's also a very serious matter for her.
I accept that, Madam Chair.
But the case arises from the Govan judgment.
If my memory serves me correctly, Madam Chair, I think it was not only that case.
Yeah, no,
There's a
there were
different
other
matter
cases.
as well.
Yeah, there were other cases. So let's see how the court, the two justices dealt with the matter. And in particular, Madam Chair, this issue of Mr. Danikas, the Greek. At paragraph 51 of that judgment, the court said this: having regard to what is quoted above, it does not seem the statement, and I quote, Giba says that they are all statements made under oath, unquote, is correct. Nowhere in Giba's answering affidavit did she make such a statement. Neither did she say any of annexes NJ2, NJ3, NJ5 were under oath. Under oath quote-unquote statements or information made only in paragraph 16 and 16.6 of the answering affidavit without suggesting that all the annexes referred to in paragraph 17 of the answering affidavit in Boyson matter were made under oath. Therefore, the statement, quote, the documents referred to as a statement by Mr. Danikas, annexure NJ3, is not a sworn statement, unquote, as stated in paragraph 31 of Govan J's judgment, has to be seen in context, as it was understood that Giba averred that NJ3 was a sworn statement. The truth is, she never said NJ3 was a sworn statement, and it could not reasonably have been so inferred, particularly reading the context of paragraph 16.7 of our answering affidavit in Boyson case quoted in paragraph 50 above. Then at paragraph 52, the fact that Giba did not avail herself to the invitation to deal with the allegation of being quote-unquote mendacious, meaning quote-unquote not telling the truth, unquote, should also be seen in context. The allegation was made in the replying affidavit. This too Govan J was mindful of. For the purpose of these proceedings, the criticism by Govan J should be seen in the context of what Giba now has to say in these proceedings. When, and paragraph 53, and I'll allow you to comment, General Boyson. When it was discovered that Boyson has raised certain issues in his replying affidavit, the prosecution team felt it needed to respond thereto. On 14 August 2013, a meeting of the prosecution team was held. Subsequent to the meeting, a memorandum was prepared and forwarded to the defense team led by Houdis SC, in terms of which it was expected that supplementary affidavit would be filed to explain the criticism against Giba with regards to the annexes. On 19 August 2013, an email by Advocate Mosing of NPA was sent to Advocate Chowki, Director of Public Prosecution, Johannesburg, inquiring what progress has been made with regard to filing of further affidavit to deal with Boyson's allegations. Subsequently, Giba was advised by Advocate Mosing that counsel had indicated that no further actions were necessary. Then at paragraph 54, based on the explanation above, it is clear that Giba did not ignore the serious allegations of quote-unquote mendacious, close quotes, made by Boyson. By seeking to file further affidavit to explain the annexes after the replying affidavit was filed is a clear indication that she was mindful of the need to, quote, explain and correct any inaccuracies, unquote, created by Boyson in his replying affidavit. Therefore, the statement, quote, despite this, the invitation by Mr. Boyson was not taken up by the NBPP by way of a request or application to deliver a further affidavit in response to Mr. Boyson's allegation of mendacity on her part. There is a deafening silence, close quotes, made by Govan J in paragraph 34 of his judgment, ought to be seen in the context of what is explained in paragraph 53 above. And it deals also with a further statement in paragraph 55. Paragraph 56, on 17 August 2012, Giba approved the application for authorization in terms of section 424 of POCA for contravention by Boyson of section 21E and F of POCA. The provisions of section 21E and F were referred to in paragraph 44 of this judgment. The information and advice that was placed before Giba for the purpose of granting or refusing authorization was prepared and compiled by Advocate Raymond Mtenjwa and Advocate Gladstone Sello Mahima, both Deputy Directors of Public Prosecutions, Advocate Anthony Mosing, a Senior Deputy Director of Public Prosecutions, and the head of the Special Projects Division, who acted as the liaison between Giba and the prosecuting team.
Madam Chair, that's quite a mouthful, but let me start by saying this. I find it astonishing that the head of the prosecuting authority in this country that takes vital decisions that could affect the liberty of a number of people, in this instance at the time 30 people, going to jail for the remainder of their lives or getting a fine of R1 billion, that litigation that took place, the manner in which it's explained to me now, it's mind-boggling. I was advised by Mr. Katz at the time when we were preparing, and I don't want to pretend to be a legal expert, that there's something like the Tantouche principle, whereby we invited her specifically to explain. We gave an opportunity to explain how it's possible that she can say under oath that she considered evidence that objectively seen did not exist at the time that she took the decision. That's one thing I would like to say. Madam Chair, but more important than that, for me, nothing turns on the fact whether those statements were under oath or not. The fact of the matter is, none of the 3 statements in the docket, and we went through them this morning with the evidence leader, Advocate Buttlinger, none of those 3 statements remotely implicate me in any wrongdoing, let alone the commission of an offence. Turning to the 4 statements that Advocate Giba added, whether they were under oath or not, none of those 4 statements implicate me in the commission of an offence. And I'm not the only one that's saying that, Madam Chair. That was indeed the finding by Judge Govan in the High Court in KwaZulu-Natal.
But Mr. Boyson, I just read to you now. That's why I read it to you, and I also referred the panel to Advocate Hode's memorandum. Ms. Giba accepted your Tantush invitation to respond to this allegation. I should actually rephrase it as a cat's invention. And she did respond to it. And he explained that as senior counsel in the case, he didn't think it was necessary for her to do so, and he argued the case.
Madam Chair, my only response to that is I find it wholly astonishing that senior counsel, I'm not an advocate, where a police officer tells a prosecutor that you are lying. And I extend an invitation to explain that between the senior counsel, Mr. Hodes, and the lead prosecutor in the country, they did not take up that investigation. That to me just does not make sense. The invitation, sorry, Madam Chair.
But Mr. General Boyson, where does Lagodi and Hughes, the judges, find that Ms. Giba was lying?
No, that's not what I'm saying, Madam Chair. I'm saying in my papers at the time, I put it to Advocate Giba that the evidence that she says she had before, objectively seen, could not have been there. Looking at the dates and the fact that the one of them, and whether it's a sworn statement or not, what I said to her at the time is, I invite you, and I accused her of being mendacious at the time. And in spite of that invitation, she never responded to that invitation.
General Boyson, perhaps you should have paid closer attention, because I thought we made some progress in terms of agreeing how this matter has progressed and where we are now in this inquiry. This inquiry concerns the conduct of Ms. Giba. We started with the Govan judgment and we moved on to the Lagodi and Hughes judgment that was concerned, in fact, primarily and only with the conduct, the GCB alleged misconduct of Ms. Giba. And the bottom line is that Judges Lagodi and Hughes found, and I will read it to you, at paragraph 63 of the judgment. This was written by Judge Lagodi. In my view, the provisions of section 2(1)(e) and F referred to in paragraph 44 of this judgment are meant for the criminalization of such activities. The point I'm making is this: courts, for the purpose of an exercise of its discretion in terms of section 2(2) referred to in paragraph 62 of this judgment, may rely on hearsay evidence, information or documentation collected by the police and presented to it by the prosecution. If that is so, and courts are entitled to have regard to hearsay evidence during trial, so too should the National Director of Public Prosecutions, Giba in Boyson's case, be entitled to rely on hearsay and similar fact evidence for the purpose of authorization as contemplated by subsection 4 of section 2 of POCA. Otherwise, pervasive presence of criminal gangs will continue to rule with impunity and fear in many of our communities and resultantly pose harm to the well-being of many communities. Then at 64, paragraph 64, he said, as I said, one needs to be careful not to be understood as upsetting Govan J's judgment for having reviewed Giba's decision to prosecute Boyson. That is not the issue before the court. The issue, however, is whether in granting authorization in terms of section 2(4), Giba was mala fide and had ulterior motive, in which event the requirements of quote-unquote fit and proper person to remain on the role of advocates becomes relevant. For this purpose, Further provisions of POCA are necessary to consider, also taking into account offences under Section 21E and F. Then he goes, then he deals at Section 66, Madam Chair, of the judgment. The essence of the paragraph 66. The essence of the information before Giba can be summed up as follows. In addition to what is stated at paragraphs 56, 57, and 60 of this judgment, Boyson was the head of the Cato Manor Organised Crime Unit in the South African Police Services. Members of the police in his unit and under his command had allegedly committed crimes of a serious nature, including murders against suspects who were sometimes framed in the commission of offences. Boyson knew, approved, and or ought to have known of the commission of these offences. In reward to the members' unlawful activities, Boyson motivated for incentive of 10,000 rand each for each of the 26 members of the Cato Manor Crime Unit, including Boyson himself. Boyson was also commended for outstanding services rendered in that he was part of a team who, through their commitment and dedication, arrested several crime and dangerous suspects for the murder of a police officer. Then at 67, the court says, I cannot find any mala fides or ulterior motive in the authorization by Giba as contemplated in POCA. POCA is like a cry out loud for declaration of war against serious, continuous, and organized crimes. The court says that needs specialized investigation and prosecution. Most importantly, POCA requires the freedom and space to be given to the members of the prosecuting authority in the exercise of their legislative power to investigate through members of the investigating directorate and under the watchful eye of a special director so appointed to prosecute without fear, favor, and prejudice those implicated in the commission of serious crimes. Anything short of this, or anything which tends to impede on this constitutional and legislative imperative, for example, hauling Giba to the proceedings in terms of Section 7 of the Admission of Advocates Act, ought to be based on very cogent, serious, and exceptional circumstances. And of course, the court here found that they were not present in this case. Now, as a person, an experienced policeman who subscribes to upholding the rule of law, this is a judgment by two judges which says, and of course, just for the record, Madam Chair, this was endorsed in the SCA, and it's at paragraph 10 of that judgment. The judgment is at B19 of the drop box. Do you accept the findings of these courts? It's two judges, Lagodi and Hughes, and then three judges in the SCA. That's 5 judges.
Madam Chair, let me attempt to answer this way. My understanding relates to the litigation process when I took the matter on review. The issue of taking the decision initially wasn't my gripe. My gripe was when I took the matter on review. What was presented or not presented as evidence when the decision was taken. And what flowed from that, the statements that Advocate Giba made then. POCA indemnifies a prosecutor from taking decisions in good faith. But that's the decision to prosecute per se. Once that decision has been taken, and there's a review application, one would expect the respondent, in this case Advocate Giba, to be open with the court. And then my gripe is that which they purport were evidence never existed. And even that which was there, the court agreed that there was no evidence. Bringing us back to Judge Legordi and Hughes and the SCA matter, there's also a minority judgment, and the matter, as I understand, is currently been on appeal to the Constitutional Court. And unfortunately, I don't have it in front of me, but I think it would be also important to see what the two dissenting judges held with regards to the conduct of Advocate Giba in this particular matter.
Which judgment binds us? You're an experienced policeman. There's a decision, there's 5 judges sitting on the bench, 3 decide one way and 2 another way. Which is the judgment that stands and that we must all abide?
Well, the answer is axiomatic, but what I am saying is one cannot discard what the 2 dissenting judges said in that judgment. And may I please just repeat that as far as I know, the matter is still going to be finalized in the Constitutional Court, Madam Chair, on the 14th of March.
I'm sure that if needs be, someone will refer you to the minority for what it's worth. And yes, the matter is on appeal. And that reinforces the point, General Boyson, that all of these matters are before the courts. They're all before the courts, but you've come here today, you've aired your gripe, you've had your say, you were vindicated before Govan J. But he said, that's not the end of the matter. I'm not finding you not guilty. In fact, if there is additional information, you can be recharged. And that is where we are today.
Madam Chair, it has been said, but conversely, he did not find me guilty either.
I think, do you want me to read this? About Brighton. No, this is the one that sees criminal investigations. Madam Chair, I'm just conferring for a minute with my... Just while my colleague is looking, just for the record, General Boyson, Section 8 of POCA deals with penalties. It's not R1 billion. I know with inflation maybe it is, but it's like R100,000 maximum fine, 100 million, and 30 years imprisonment. So 100 million is not R1 billion. I think R1 billion is 1,000.
No, how much is it?
It's a lot. It's too much.
And you say it's not life, it is
30 years.
30 years, but 30 years is...
Yes. It's up to a maximum.
Madam Chair, the document that I have in front of me says otherwise. Section 3
What does it say, Mr. Boyce?
speaks to penalties. Any person convicted of an offence referred to in Section 2.1 shall be liable to a fine not exceeding 1,000 million or to imprisonment for a period of up to imprisonment for life.
Chair,
How much is 1,000 million?
I think that's $1 billion, is it not? That is $1 billion.
Yes.
But Chair, if it assists, I have due to stat open on my computer, and I can confirm that what General Boyson said is the most recent version of it.
All I can say, Chair, is that some of us have no inkling about these numbers. They just boggle the mind. So that is why we're trying to understand them.
Yeah, money's always been way over my head. Not good at money. But
Okay, you may proceed.
That's section 8. I was reading from section 8.
Section 3.
Anyway, I was reading from section 8.
Section
I don't know
3.
if section
Section
3
3.
is the relevant provision.
Which is the relevant provision, 8 or 3?
Chair, section 3 I would submit is the relevant section, which is penalties. It comes immediately after the offences section, which is section 2. And it refers to section 3.1 says any person convicted of an offence referred to in section 2.1, which is the section under which General Hoffman would have been General. I think the cold has now got to my head. General Boyson would have been charged. So the appropriate section for the penalty would be section 3.1, and that says any person convicted of an offence referred to in section 2.1 shall be liable to a fine not exceeding 1,000 million or to imprisonment for a period up to imprisonment for life. And 1,000 million, as I understand it, is 1 billion.
Section 8, what does Section 8 provide for?
Also penalties. Penalties of the same offences.
Chair, section 8 says 8.1, any person convicted of an offence contemplated in section 4, 5, or 6 shall be liable to a fine not exceeding 100 million or to imprisonment for a period not exceeding 30 years. General Boyson would have been charged under section 2.1. So it's not section 8, it's section 3.
But it is also 1,000 million.
No,
100
no, it's
million.
not. That is 100 million. It's a
100
lesser.
million and 1,000 million.
That's correct.
So 2.1 is 100 million.
2.1 is 1,000 million.
So it's more serious then.
Yes, indeed.
Okay, thank you. Are you still with us?
General Boyson, you were the fourth respondent, you may recall, in a matter that came before the Durban and Coast Local Division on the 14th of November 2008. The applicant was Bongani Alphas Mkhize. Do you remember that matter? What was sought and what was ordered by consent between the parties is that the respondents, including you, are interdicted from unlawfully killing, injuring, threatening, harassing, or in any way unlawfully intimidating the applicant. Do you recall that court application?
I do, Madam Chair.
So this was a case where Mr. Mkhize, fearing for his life, was then asking for protection from the court. You know what happened to Mr. Mkhize subsequently? Or don't you?
I do, Madam Chair.
Can I show you this picture? Can we show, have we got another picture for that? Do you recognize the person in that picture, and can you describe it?
panel, I hate to interrupt Mr. Arendse at the best of times, but when my client has indicated that he wishes to assist the panel in whatever way he can, it's even my inclination is even stronger. I think it would be helpful. Excuse me?
We can hear you, but I don't think everybody can hear you.
So I was saying that I hate to interrupt Mr. Arendse at the best of times, in particular in a situation where my client has indicated that he wishes to assist the panel in whichever way possible. However, when there is what appears to be a suggestion that my client was involved in a particular criminal event unrelated to the charges upon which he was indicted so many years ago, then I do begin to wonder whether it's appropriate that my client should be subject to this type of cross-examination at all. It doesn't seem to me that the kinds of questions which are coming would fit into the terms of reference of this inquiry, quite frankly. The terms of reference relate to the fitness, or under Section 12(6) of the NPA Act, of a particular or two particular individuals, and this evidence relates to one particular, it seems to me, one particular event many years ago, unrelated to my client in any way, who's not the subject of this inquiry in any event.
It would be helpful, I think, if we know what the line of questioning is aimed at.
Madam Chair, it relates to counts 20 to 24 of the indictment, which forms part of the decision to prosecute General Boyson.
Yes, you see, Madam Chair, that's the very problem.
So
my client was not charged with counts 20 to 24 at all. He's not subject to 20 and 24. That's the difficulty that I have with the kind of evidence that's coming before that is intended to be. So Mr. Arendse's answer to the panel demonstrates the very point that I wish to get across to the panel. If it had related to some of the charges in particular that my client is facing, perhaps it might be admissible, but not on the basis of the evidence that, and in any event, the evidence that is now being put before the court wasn't part of the papers that served before Judge Govan.
You might want to indicate, Mr. Arendse, what the value of that line of questioning is in this matter.
Madam Chair, this photograph, this terrible photograph of Mr. Mkhize, who had, in desperation, sought protection from the court, it counted for nothing because subsequently he was shot and killed. And what this picture shows is a man slumped in his car, in his driver's seat.
What's the value of that?
The value,
process?
what happened, this is according to my instructions. If they're wrong, then they're wrong. My instructions are that the ballistic reports links the Cato Manor unit to the killing of Mr. Mkhize, who had previously sought protection from the court. So it traces the bullets, and the overall charge of running an enterprise, the 2, 1E and F charges, relates to General Boyson as the head of that unit. That's the link between the two. I've been requested by my team to raise this with him, and whether to his knowledge he's aware of this.
Does it have any relevance to any charges which might have been laid against Mr. Boyson? Was he charged with Mkhize's killing or anything of the sort?
Well, that's what I've read to you from a piece of paper that was, it's 20, counts 20 to 24. Relates to...
That he was charged with the killing of Mkhize?
It involves the killing of Mkhize.
We've just been told he was not charged with those counts. I think
that's the question.
The chair wants to know.
Yeah, was he charged with those, with Mkhize's killing?
Yes, some of the other co-accused, some of General Boyson's co-accused were charged with the killing of Mokgoro, but certainly not General Boyson, and that's the point.
We've heard evidence all morning, or evidence was laid, how Mr. Boyson could not be linked to those actions of the Cato Manor unit, except that he was head of the unit. But the actions of the unit could not be linked with Mr. Boyson. We heard that all morning. So I was just wondering how Mkhize, may his soul rest in peace, how his death is linked to Mr. Boyson, whether Mr. Boyson was charged with the killing of Mkhize,
Madam Chair.
or the death of Mkhize.
Madam Chair, I would just like to make one comment if you would allow me to. In this very Mkhize matter that's been referred to now, subsequent to his shooting, the family instituted civil proceedings against the Minister of Police at the time. The Minister of Police, in civil proceedings, filed a statement under oath in which he said, the Minister of Police said, the shooting by Cato Manor was reasonable and justified.
I'm still waiting for an answer to my question.
Then that's what the minister said. Then there's no issue that, one, Mr. Mkhize was shot by the Cato Manor unit. They shot him and they killed him. But the force that was used was reasonable and proportionate in the circumstances. That is what the minister is saying. And the 21E and 21F in particular charges relates to General Boyson as the head of that unit. He has now confirmed that he knows about the Mkhize killing and that he was killed by the police. And that is what I was putting to him. And prior to that, he was aware that the same Mr. Mkhize had sought an interdict to interdict them from killing him.
But you still have
Now he
not
said it's a
answered
lawful
my
killing.
question. He has not been charged with Mkhize's killing. Is that right?
Well, my instructions are that it's part of the indictment. That's my answer.
Is that
And if I'm wrong, and apparently the indictment was made available or is or has been made available to the evidence leaders.
do we have that information, Ms. Bartlanders?
Chair, I will have a look.
So, Chair,
My view at the moment is that he's
No,
not actually charged with Mkhize's killing, but I will have a look to
Chair,
verify.
what happened was, there are, let's say, an X number of people who are charged with 116 counts. Most of, all of the accused are not charged with all the counts. So what's happened is there's been a joined under the Criminal Procedure Act of all the accused in respect of multiple charges. So General Boyson has been charged with, for example, charges 1, 2, and 8. In particular, he hasn't been charged with counts 20 and 24, as have many of the other co-accused. There are 3 or 4, I think it is, who've been charged with counts 20 and 24.
Now, that is the information that I'm looking for. Okay.
Can I find out, in the charges where he has been charged, are those charges in any way linked to the 24 and 25, either in the main or in the alternative? Is there a link between the charges that he's charged with the 24 and 20 and 24?
What's the response?
No, sir, the answer is, as we would have it, no.
You're being directed to the indictment. Are you able to agree with Mr. Katz, or you're not able to agree? Because it would confirm whether we allow that line of questioning or not.
I don't agree with Mr. Katz.
I didn't hear that, sorry.
I don't agree with Mr. Katz.
Oh.
I agree with him about a lot of things, but not today. Can I request
Not
this?
with this submission.
May I request this? I have come to the end of my cross-examination of General Boyson. I'm not sure whether we're going to continue today or whether any of my other colleagues are also have questions of General Boyson, and then I will try to get some clarity about this. And if I'm wrong,
Fair enough.
I'm quite happy to withdraw the question and whatever.
Can I make a suggestion, Mr. Arendse? Because it will not be helpful for you to be directed to things that you haven't had time to consider. I would imagine that you should be given time to look at the indictment, study it, so that you're able to ask that question in a more directed way. So my suggestion would be, if you could, take time to look at it and come back. It might be that we might excuse Mr. Boyson, and depending on the parties, whether that question might be asked of him on paper, or I don't think he should be come back if that's the only, unless there are other related questions that you want to ask arising from the questions you would want to ask. But I would suggest we don't do it the way we're trying to do it now.
And the idea is still to determine the fairness of the question, of the statement that you're putting to him, okay?
Yeah, I think just in sort of conclusion of this, it's not easy to understand the way poker works, but you have an enterprise that is conducted, obviously with a criminal purpose, and then you have these what is called predicate offences. Now, to that extent, my colleague, Mr. Katz, is correct, and Mr. Boyson, he hasn't been charged with any of those predicate, those individual, because it's the predicate offences that informs this enterprise that is conducted. But count one definitely involves all of these offences. In fact, it's count one accused one, that's General Boyson, 6, 9, 15, and 16 of conducting these unlawful activities over a period May 8, 2008 to September 2011, and all of these killings are involved in that count, as I understand it.
And now I want to know if Mr. Boyson has been charged with the killing of Mr. Mkhize. Simple. If you do, as Ms. Moroka has indicated, maybe it will be helpful. Or study the indictment so that you're able to answer that question directly and specifically, and help us to understand and have regard to the fact.
Perhaps the panel, maybe I should help Mr. Arendse a little bit further, because he made another suggestion about something that I said which I didn't say. What I said was that General Boyson has been charged with counts 1 and 2, and I can confirm, he has also been charged with one predicate offence, and that's counts 8, I think 9, 10, and that relates to the event where the helicopter arrived in Howick. So there's one of the, let's call it predicate offences, in respect of which General Boyson has been charged, but certainly not the Mkhize incident. So when Mr. Arendse suggested that he hasn't been, with General Boyson hasn't been charged with any predicate offences, that's not true. He has been one, and we know what General Boyson put before the panel this morning, what the evidence is relating to him in respect of that charge, that one predicate offence.
I think the suggestion has been made, so
Yeah.
we'll try
We'll come
after
back.
hours or overnight come back with this, and we could put it on paper to General Boyson, or I may end up having to withdraw it completely.
Was that your last?
Thank you,
question?
General Boyson. Thank you.
Yeah.
I've got no further questions.
Okay, thank you, Mr. Arendse. Mr. Ramaele.
Ramawele. Ramawele, yes. As I thought early this morning, I've got no questions.
Okay.
Thank you,
Thank-
Chair. Thank you, Chair. Just a few questions.
Wait, how do we pronounce your surname?
How do you spell it?
No.
It's Ramawele,
Ramawele.
yes.
Okay. Ramawele.
Correct.
Thank you. Ms. Butlender?
Thank you, Chair. Just a few questions. Chair, the issue of the transcript and Advocate Hodis was raised. We submit that we'll deal with the implications of that in argument, so I won't say anything more about it now. General Boyson, you were asked about whether or not it was premature for you to come here today because there are all these pending applications. But you'll be aware that the terms of this inquiry are to look at essentially three cases. One of them is the case that you raised, reviewing the decision by Advocate Giba to authorize a prosecution against you. And that resulted in the judgment by Govan J in the KZN High Court. Is that correct?
That's correct, Madam Chair.
So you'll agree with me that one of the questions before this inquiry is not whether Govan J was right on charges which were proffered against you, because that wasn't before Govan, but rather whether the conduct of Advocate Giba in authorizing your prosecution was lawful, and whether, well, not whether it was lawful, but whether it disclosed any conduct that related to her fitness or propriety to hold office. Is that correct?
That's my understanding, Madam Chair.
And then you were asked about whether or not the fact that there were all these other pending applications precluded you from speaking now and giving this evidence now because everything is pending. You'll correct me if I'm wrong, but I had understood that the pending applications related, other than the Govan one, which you were successful in, you were charged again by Sean Abrams. And so what is pending is a new charge based on different facts, based on different information that was then placed before Sean Abrams when he authorized that decision. Is that right?
The first part of the statement is correct, Madam Chair, but the prosecution by Advocate Sean Abrams is based on exactly the same facts that Advocate Giba used to authorize my prosecution, with the exception of one statement that they've added, which in any event at the time was at the disposal of Advocate Giba, which they very belatedly now added, of a deceased person.
Yes, so the evidence before Sean Abrams was different to what was before Advocate Giba.
I would say slightly different, Madam Chair.
Okay. And then my last question relates to a question that was put to you about Advocate Giba's referring to Mr. Danika's statement, and the suggestion was made that there was nothing untoward in her referring to it as a statement. She never said it was under oath. You were read to from a judgment. You recall that?
I do, Madam Chair.
Okay. Can you go to Advocate Giba's answering affidavit? I think I'm not sure if you have it in front of you. You may have to put it up on the screen. It is the answering affidavit in the Boyson matter. You just bear with me. It is Bundle G, Folder 5, Item 5.1.31. If you please go to paragraph 24.5. Thank you. 24.5. 24.5 says the applicant has failed to demonstrate to this court in what respects the decisions sought to be impugned are justifiable, irrational, unreasonable, or untruthful. You see that?
Yes, unlawful.
Sorry, unlawful. I said untruthful. And then Advocate Giba says he is directly implicated under oath in the statements placed before me in annexures NJ2 to NJ5. You see that?
I do see that, Madam Chair.
And you are, you've read this affidavit before, I assume multiple times.
I have, Madam Chair.
And you'll confirm then that, that annexures NJ2 to 5 include the statement, unsigned statement by Mr. Danikas.
Those will be the two statements of Ayer, the one by Londlo and the one by Danikas. The unsigned one by Danikas.
Thank you. I have no further questions, Chair. You can raise it.
Advocate Arendse, Mr. Arendse, on the last point which had been raised with Advocate Boyson, we have throughout the inquiry, General Boyson, yes, we've been, since the beginning of these inquiry proceedings, we've tried to manage what goes out there in the media as regards the proceedings of this case. And I mean, you would have seen that there was a point at which the chairperson did basically speak about certain comments that we would not want, you know, to be out there because they could be damaging to individuals. So I understood you to say when you were going to go back and look at the indictment in as far as General Boyson's is concerned, that last point, and that the matter could be addressed by way of a letter or by way of a withdrawal. I would suggest that the withdrawal be made within these proceedings, because remember now it's been said in this forum and it's there out there for everybody, and to just withdraw it by way of a letter, if you do indeed withdraw, we don't know what is going to happen, would be a bit unfair in the circumstances. So I would prefer basically that be dealt with at least within the same forum that it was raised, so that we don't leave certain things hanging and it is as though there's a truth that's being, you know, put out there within these proceedings, which we're not really certain of.
Ma'am, may I say this?
And just to add, the converse applies, if you're right.
Yes. If I withdraw anything, it will only be that General Boyson has not been charged with Mr. Mkhize's murder. We know from his own evidence, the minister has admitted to the killing of Mr. Mkhize by members of the South African Police Services, but their defense is that it was reasonable and proportionate in the circumstances. We also know that Mr. Mkhize was killed by members of the Cato Manor unit. The question is whether Mr. Boyson was charged. Now, I did not say he was charged. I asked whether he was aware of this, because my understanding of an enterprise is almost like running a business. That this unit, this is the thrust of the charge, that they were in the business of killing people, especially so-called criminal suspects. That was their business, and the charge is that either General Boyson knew or he ought to have known that they were conducting such a business. So what I need to do for myself and with my team is to clarify to what extent General Boyson is implicated in let's put it neutrally, the killing of Mr. Mkhize, I think.
My question was whether General Boyson has been charged with Mkhize's killing. And that is a question that needs to be answered.
Okay. Yes,
Thank you.
and the initial submission that you made was to the effect that in the indictment, that's when the argument started. That's why I actually raised that point to say, I have no difficulties with other submissions that you've made. However, I'm just saying on the point which still needs clarity on, about whether General Boyson has been indicted on that charge. I would, for purposes of these proceedings, it would be better if we clarify that within this forum instead of just doing it, outside the forum and leave the media reports hanging, in essence.
Chair,
Yes, you may.
while sitting here, I received a WhatsApp from the senior evidence leader to ask me to ask the panel whether or not the panel would be interested in me providing some further detail about the pending litigation. I don't have a particular desire, but if the panel requires some further, I would be the person to understand where it is in the General Boyson review of the Abrams decision et al. I could, if the panel wishes, give that explanation. I'm neutral. And the other question is, I do believe that Mr. Masuku has a copy of the indictment, or is there no indictment, or Mr. Orence's team has a copy of the indictment. I could look at it right now and show the panel or show the team why I would make the submission that General Boyson has not been charged with counts 20 and 24. I could show them right now. It's as simple as that. It's literally a 2-minute exercise.
No, my preference, because it was raised by Mr. Arance, let him respond to it and not you.
Yeah.
That would be our preference.
I think you might want to put it in writing and share the information with both.
As to the processes that are currently the
Under-
review proceedings.
Yes.
I will provide, at the request of the panel, I will provide that, an outline of those processes with some other objective submissions on if I may.
Purpose with that, sir, Madam Chair? Are we
I
going to be
think-
lectured here?
No,
Or taught
no.
what we are about? We
I
know there are
think-
review proceedings.
Yeah.
They are
No,
not.
no.
They are not strictly relevant to these proceedings. They were only raised in the context of saying or asking Mr. Boyson, now what was the point of coming here to prove your innocence and to tell us what's all in these statements when all these proceedings are still pending, including the criminal charges?
We as the panel would prefer that you direct that information to both parties instead of us. If they feel there is need, or if they value the information for their purposes, they will address them. But if they don't,
I'm
They
neutral.
can be
As I said, Chip, I'm neutral on it. It was the evidence leader the lead evidence leader that contacted me to ask me to convey her thoughts to you, and I'm just conveying them. I have no
we
preference.
Chair.
Because she's got a
not,
team.
just a minute, Mr. Arance, we prefer not to receive evidence directly.
And if
That's it.
and
Yeah.
Chair, would you wish for any objective comments, what Mr. Orense calls a lecture, unrelated to any?
Related, directed to the evidence leaders and to
As
the parties. Thank you.
Chair, if I may just, I'm not sure if this would help Mr. Orense. As far as I can tell from the Dropbox, the indictment's not on the Dropbox. But if you look at item 5.1.38 in folder G, let me just double check. If you look at folder G, which is the court records and the documents per case, and then if you go to number 5, which is the Boyson case, and then 5.1 below that has the court record in the Boyson case. And if you then go to 5.1.38, there is a summary of substantial facts there. Now, I assume that this was before the court in the KZN High Court. And if you, I would ask Mr. Arnser to consider this before he reverts to us, but if you look at page number 9 of that document, it details counts 20 to 24, which I think were the counts at issue, and it says underneath that it relates to accused 2, 3, 14, 19, 20, and 21, and to the killing of Bongani Mkhize. So it would appear that accused number 1 would be Mr. Boyson was not there. But I just point you to that if it would assist you in considering the indictment, and we'll wait for your response on that.
In that regard.
Thank you, Chair.
So we are done with Mr. Boyson, okay? But we wish to thank you, truly thank you for your willingness to come and to make the time to come to assist us with the evidence that you led. Okay, we appreciate it wholly. Thank you. And thank you, Mr. Kuss, for assisting him. We will adjourn until what time tomorrow?
Chair, tomorrow, as I understand it, everything's a little upside down.
Yes, I know.
For which I apologize. Tomorrow, as I understand it, we'll ask Mr. Rulofse to come back in the morning to face his cross-examination by Mr. Ramawele.
What time?
And that's then followed by re-examination of, or the ending of Advocate Hofmeer's evidence and re-examination. So I think maybe if we started at 9:30, it would just give us a bit of flexibility, if that suits you.
9:30 tomorrow morning? It's okay. Thank you. We adjourn until 9:30 tomorrow morning. Thank you. And thank you to everybody, okay, including Mr. Aronson.
Thank you.